This program is brought to you by Emory University.
So today we have with us Willie Lovett, Trenny Stovall, and Aimee Stowe. Their biographical information is provided to you in the materials along with the presentation slides for their talk today. We chose this topic on child's right to counsel because if you're engaged in this work or following this work at all, you know that this is a hot topic for us at this time, both nationally and certainly within the state of Georgia. We're having a comprehensive juvenile code revision that will go into effect January 1st. We've had a series of cases that have been recently decided on appeal at various levels that have either clarified or further confused what we thought we knew about the scope of representation and the child's right to counsel in child abuse and neglect proceedings. So who we've created as our panel here today are experts from Fulton and DeKalb, which both, for various reasons, have some unique attributes, but these folks have been on the ground leading the state in terms of understanding and implementing what it really means to provide a child with the right to counsel in Georgia. So they're the folks we want to hear from, and they're the experts. And with that, I'm going to ask that they step in and turn the presentation over to them. Please join me in welcoming them, and I invite you to the podium.
Hi, hello everyone. My name is Trenny Stovall. I'm the director of DeKalb County's Child Advocacy Center. We're attorneys who represent children in a dual role of representation. We'll talk about models of representation today. I don't know if you want to all introduce ourselves. You can get started. You want to do now? Sure.
I'm Aimee Stowe. I work at the DeKalb County Child Advocacy Center. I'm a child advocate attorney, as Trenny mentioned. I practice in a dual role. Of course, you'll learn about that in a second. But I also coordinate our appeals practice in DeKalb County.
And I'm Willie Lovett. I'm the director of the Fulton County Office of the Child Attorney. And we do a client-directed model of representation. So you'll be able to get different perspectives from the different panelists.
So I guess we'll start with, I wanted to ask, do we have all attorneys in the room? How many people who aren't attorneys are in the room? Well, that's wonderful, excellent. And I also wanted to know, in your counties, wherever you may practice or work, are attorneys generally provided for children? So are there independency or deprivation matters? How many people work in counties where attorneys are not consistently provided for children? What county are you from?
In DeKalb, when you guys conflict off a case, it only gets a GAL outside, that's my understanding.
Really? Really? I'd love to talk about that. Actually, rarely do we conflict off of cases, and I'll wait to get to the point to talk about that, but that's a very good point to start. And someone else mentioned that they don't always have attorneys.
I practice some in Walton County, and they get causes until there's a termination usually. Occasionally there'll be an attorney appointed during the pendency of a case, but it's rare.
So as Melissa mentioned, we have a new code that's coming out, and the wonderful thing about it has many complexities and people have different opinions, but the reality, the best thing about it is that attorneys will going forward be required for all children in what will in the future be called dependency matters. So excuse me if I vacillate between deprivation and dependency. We're going to join the rest of the country and start referring to matters in which children are found to be or alleged to be abused and or deprived as dependency instead of deprivation. We found that we were one of the very few states left that talked about that. So this quote comes from the American Bar Association's section of litigations committee for a child's right to counsel. And it's really important as we start talking about this to really consider what's the relevance of children having attorneys, right? When I started doing this work, children probably had guardians ad litem about 20 years ago, and then sometimes when CASA came into it, they got CASAs, and every now and then they got attorneys, and sometimes the attorney was appointed as a guardian, or appointed as attorney for the child, or both, or sometimes the attorney didn't know how they were appointed because the orders didn't matter, and that's something I want to make sure I make this point if I don't make it later. It's really important as you go forward, if you represent a child in a deprivation, in a dependency matter, that your order is very clear as to your model of representation or how you're appointed to represent them. That's important as we go forward, and we're going to talk later about some appeals that have that have happened very recently and some decisions by our courts of appeals that really bring into question the rights of a child and the role of counsel in representing that child. So it's going to be very important that you know how you're appointed to represent your client. I sit on that committee with the ABA, and we talk a lot about how the relevance of an attorney. How do we carry that out? If you work in juvenile court and you see the difference when a child has counsel versus when they don't, whether the child has an opportunity to even be present in court often depends upon whether or not they have an attorney representing them, and whether they are present or not, whether their interests are adequately protected has a lot to do with whether their attorney is present. And then we'll talk about later about quality of representation, which is just as important, if not more important, as to the name that the attorney has or that advocate has when they're representing them. But when we talked about ways that we can show the significance of attorneys, it's really hard to capture that, right? Because we don't work in isolation. We're part of a very large system, and the work of the attorney is very significant. However, it does not on its own, rarely on its own can you kind of identify that this outcome happened solely, purely because an attorney represented the child. Most importantly, though, we know that when you serve as an attorney for a child, often your work is just as much social work as it is litigating in the courtroom, but it speaks directly to the outcomes that your child client may have. We've learned that as we do this work, there have been some studies done, and they show that children reach permanency faster when they have an attorney representing them, that their matters don't languish so long, time period going on without matters being reviewed, case plans going on without any consideration as to whether or not they've been adhered to, or if the parties are meeting their obligations under the case plan. It's really important that the attorney be present and participate, not just in the courtroom, but in all of those stakeholder efforts that go to achieving permanency and meeting the needs of those child clients. That children transition to adulthood more successfully when they have counsel. When there's an attorney representing the child, there are certain hearings, and especially with the new code, there's a total change. I was reading it recently and going, wow, the difference in the amount of review hearings that have to happen, when permanency hearings have to happen. In DeKalb, I work in DeKalb, and about a year ago, we started looking at the permanency and the transition hearing, the last hearing that the child had prior to aging out of foster care, and those hearings were occurring about 2 weeks before they aged out of foster care. So we find out that that child doesn't have a place to go, doesn't have a permanent connection, doesn't have an ID, doesn't have fill in the blanks. There's not really a lot that can be done with that, and they don't have hearings after they turn 18 in Georgia, whether they sign themselves back into care or not, or has not signed themselves back in care, or has not participated in that transitional living plan and has no idea what that plan was supposed to provide for them. So it's really significant when there's an attorney assigned to the case to ensure that the procedural rules, those matters that should occur in certain times occur, so that your client can have access to the court, and the court can really consider whether or not the goals are being achieved and the obligations of the parties are being met. And it's your job to ensure that your client, and many might not agree with this, but I think, so if you take on the responsibility of representing a child in foster care or who has been found to be abused or neglected, that your job is to ensure that their needs are being met. That means that maybe you can't obviously identify and provide those services, but ensure that the proper assessments are made, ensure that the court actually considers those assessments, that they're submitted on the record, that parties are held accountable for not complying with what the findings are. Those are responsibilities of the attorney representing the client, and you have the obligation and the opportunity. What you can do that an advocate that's not counsel can't do is ask for a hearing and present these matters on the record, ask for findings of fact and no reasonable efforts, and all of those things that you need to do to get the ball rolling and push it forward so that your clients can have their services, their needs identified first, comprehensively, and met. And that it's also been found that children and youth, especially, who are involved in the system that have counsel, when they are when they understand proceedings, and no one can explain to your client the value of, the purpose of, and the intent of a court proceeding better than counsel for that child. That's your job to explain that to your client. That's an ongoing relationship. Establishing rapport is not just seeing them and chatting about the weather or about what mom has done. It's their part. They are parties, and it's their part in this action that they need to be made aware of. Our clients are way more aware and smarter than we give them credit for. They've had life experiences, unfortunately, that have propelled them forward in a level of maturity in some ways that many of us don't give them credit for. And when you interact with your client, it's your responsibility to ensure that your client understands the court proceedings, that they're encouraged to participate in them. I hear all the time that they just don't want to come to court. Part of that is your job, to engage them so they participate. And clients are much more likely to comply with court's orders, and that manifests itself by placement stability. Think about teenagers who move from place to place. If they understood better that you took the time to understand what their goals were, to counsel them about what outcomes they wanted, to address those things with them, and that they're present in court and saw that you advocated for them for that they were able to understand, whether in court or by explanation with you later, what happened in court and why things turned out the way they did, whether it's in their favor or not in their favor, they're much more likely to comply with counseling. You have kids that go to counseling all the time and sit there, and it becomes a checkbox, but nothing gets done. And after those 90 days of services that were, it was evaluated, that box gets checked off and your child gets no more counseling because they're cured, right? They're healed. Everything's great. No, they're much more likely to participate if they understand there's a connection made, and you as counsel for the child have a responsibility to talking to your client about all of those things relating to their case. So representing the child. According to the ABA model, and Georgia has, the new code allows for a different model of, does not require, but allows for a different model of representation. But according to the ABA model, the child's attorney should represent the child's expressed preferences and follow the child's direction throughout the course of litigation. So this has been the subject of much debate in Georgia, and many of you in this room are familiar with that. For those of you that aren't, there are basically three models of representation that occur in Georgia. Those include best interest, which means that you as the attorney represent the best interest of the child. That becomes your client. The child is relevant and important, hopefully, but your job is to represent that client's best interest. Effectively, you serve as a GAL that is also an attorney. Client-directed representation, where that child is your client, and your responsibility is to treat that child just as they were a client as much as possible as you would any other client. Follow their directive and allow them to set the goals of their case. Your job is to counsel them, though, and Willie, because that's his model of representation that his office practices, will explain that to you in detail. And then dual representation, which is the dual model of representation, which is what our office practices, says that we serve as both attorney and guardian ad litem for the child until such time as there is a conflict that cannot be reconciled, and then we would have to leave our role as guardian ad litem and continue to serve as counsel for the child. So, and there are a couple other models that happen in other states that we'll talk about very briefly. So it's an interesting, I had a conversation with Michelle Barclay, who runs an office that has for over 10 years now done a lot of research around the state, really assessing the models of representation. And what we find is that all of that and some of that happen in most places around the state. And oftentimes what we find is that the court's orders don't specifically identify what that role is. So you just kind of know what you're supposed to do, one would assume, and you kind of represent that client that way. But it is really important to know what your responsibilities are. Aimee will talk to you about our rules of ethics and how they apply with relation to whatever your role, your appointed role is. So I can't underscore enough how important it is that you ensure that you understand what what your appointment is, so that you understand what your responsibility is. So for best interest attorney, it's what we did for many, when I started this work like 20 years ago, and someone came to me and said, you shouldn't call yourself a guardian ad litem. And I was like, why? Because nobody ever told me anything about it. You should be child advocate attorney, because as guardian ad litem, you can be called to testify. And if you're attorney for the child, you have responsibilities of confidentiality. So those two don't coincide. I didn't understand those complexities very well, and that's why I'm great enough to have a smart young lady who's going to talk to you about those complexities and rules of ethics. But the truth is, as best interest attorney, many of us feel more comfortable with that. That's the model of representation that you can get laypersons, oftentimes people who are legislators who provide money and who change or who pass legislation that establish our laws, can understand that. They're children, right? Forever, we've thought of them almost, we don't like to say it, but basically we've thought of them as chattel. They're like property. So they're kids, and we love them, and we'll listen to them. I mean, we'll hear what they say, but they don't really know what's best for them, and it's your job to do what's best for them. And that's how many of us practice. And even though we work in an office and we consider ourselves pretty sophisticated in this, the reality is when you get a case and your client wants to do something that you don't find to be reasonable or is best for them, the natural, and I hope that this is natural for everybody, your natural pull is to say, I need to do what's best for you, but your responsibility is to counsel them, because whatever your role is, your client is a party and has a right to have their interest, their wishes expressed to the court. So the pros of best interest representation is that you represent that child's best interest. You are not bound by what that client tells you, what they want. One should hope that if you are serving in that role until until January of next year, when the new code takes effect, that you will consider greatly what your client's wishes are, and that you take very seriously your responsibility as counsel to counsel. That is your job. A colleague once used the term attorney plus, and I really kind of adopted that for what our role is, and I'll talk to you about dual representation, but as an attorney, no matter what the capacity of your client is, you should really attempt to convey to them what their circumstances are in a developmentally appropriate manner, and attempt to elicit from them what it is, what outcome they want. But it's your job to strategize to get to that outcome. And part of that counseling has to do with, I understand that you want to live with Aunt X. I get that. However, there are things that need to happen before. And my job is to explain to you, if we go forward today about that, maybe we should talk about how we get to that end in a way that will actually get you to that end, because I don't make that decision. And if represented to the court that you have no understanding that your Aunt X lives under a bridge, maybe the court might not be willing to hear what you say. But there's a way that we can get to that end. And your job is to counsel your client so that your client is able to understand at a developmentally appropriate way how you reach the end that they want. But never bypass that responsibility to strategize and to counsel is most important. But back to best interest. So when you have, this is great for clients who are nonverbal. You ask the question, how am I supposed to know what, my client doesn't speak, they're babies, or maybe they have a disability that doesn't allow them to speak. Willie will talk to you about substituted judgment and responsibilities there, but if your role is best interest, your job is to evaluate what you believe is best for them, or not what you believe, what is best for them in their circumstances. And it's really important as attorneys that we step out of ourselves, as you would with any other client. If you had an adult client that was paying you money and they wanted to do something that you thought was, well, let's think about divorces. If we were talking about adult clients and divorces, we might think that they want to do some things that are pretty insane sometimes because they're emotionally charged. But you do it, right? So with your client, even though you have a responsibility to abide or protect or consider their best interest, you need to put yourself out of your shoes, out of your professional, sophisticated shoes, and in the circumstances of this child, where they're, with their background, with their family connection, with their resources, opportunities, obstacles and find out what would be best for that child and assess what would be best for that child in this circumstance. Your job is then to make a recommendation to the court with regard to what's best and advocate for that. So for nonverbal or clients who are unwilling, oftentimes, especially with teenagers, it's not interested in the process. So it becomes easy to say, I'm going to do what's best for you because you obviously don't know what's best for you, right? And in those instances, that's when best interest seems to be a more appropriate role. It allows a child to avoid the pressures of having to make decisions when they still have to live and deal with that family, right? They have to make certain, a child client who might not want to return home might not be willing to express that, not in private to you and definitely not in public to the court, because they've got to do that in front of their family. Or maybe even if they don't want to go home right now because I really want mom to get help for that drug problem, when they have that responsibility, when you leave it to them to express that, and you're going to stand up in court, let me understand, I'm going to tell you this, and you're going to stand up in court and tell the judge in front of my mom that I said that? Do you see what I'm saying? So sometimes, even though we have a responsibility to elicit from our client what their expressed interests are, sometimes when you think about best interests, it makes it easier to say, well, we can bypass that. But again, you as counsel for your client have certain responsibilities to, as best possible, to elicit what they want and find a way to protect their interests while you secure that outcome for them. And another argument for best interest is that it allows the attorney to provide that comprehensive information to the court. So the reality is DFACS represents not particularly the child, they represent all of us. They have a policy, a public policy responsibility to protect children who are deprived and protect the community, right, and serve the community. So they may not, for whatever reasons, have all the information and be able to provide it to the court. And the Parents Council obviously has an interest, is biased and has an interest in protecting their client. So you as a child, if you serve in an express role, you may have some prohibition from revealing information that might otherwise, go to that child's best interest, but not go to what that child, the outcome that child wants. Does that make sense? So in that instance, that's why also in our new code, we have a shall now. There shall be a guardian appointed, and that role of that guardian would then to evaluate those missing pieces, that information that never got in that the court might need to consider in making a best interest in determination.
Can you give an example of a fact that you might hold the attorney for the child that the guardian might review?
Sure. I represent a client, and she is 13 years old. So she's been in care for a couple of months, and mom was supposed to do A, B, and C, and mom's done A, B, and pretty much C. She's been having weekend visits at home, and part of the safety plan, or part of the agreement, is that mom would no longer allow her boyfriend, who was abusive, in the home. Pretty simple, right? If you've done this work, you've had this case. So for those 4 or 6 months, whatever, when the visits have occurred in the home, he's not been in the home, his clothes aren't there, the apartment has looked, there's no evidence that he's residing in the home. We're doing weekend visits, and we're in the process of transitioning the child back to the home. Well, she comes and tells you as counsel, I'm ready to go home, I can't wait to get home this weekend. Buddy's gonna take me to McDonald's. Oops. You confident? This is a confidential matter. I do not want you as my attorney to tell anybody that I'm ready to go home. I'm done with DFACS, I wanna go home now. That's an example of that information. If you serve in the role as client director, you can't reveal that confidence. If you're a best interest attorney representing that child's best interest, you can reveal that confidence. You may have a responsibility to reveal it. And another reason it's important to know what your role is, you need to say that to your client up front. Mm-hmm. If you're in a dual role like we serve, there goes that trigger, and we enter conflict analysis and have to determine, does this information rise to a level that as guardian for this child I have a responsibility to reveal the information, but as attorney for the child, I can't. Mm. So as attorney for the child, I can't reveal that information. She's told me, and if we believe that it would put her in not necessarily immediate danger, but in there's a serious chance that she might be harmed, or there might be a serious negative outcome. We might have, in my role, we might have a responsibility to conflict out of the case. And as much as I abide the role and recognize the value of a dual role in some instances. 6 months into the case to say I need to conflict off now, right, as guardian for the child, and to have somebody from the outside come in, might not be the best time to do, and that new guardian might not have an opportunity to really evaluate that information. So that's a good example.
May I follow up that question?
Yes.
Oh, I'm an alumni from School of Medicine, so I'm kind of new to this group.
Okay.
So, does the children know, or the kids know, that what the definition of lawyer and attorney to them?
Well, let's go back to the very beginning. After you get appointed, your first conversation with your client, you should explain to them who you are and what you do. And every time you talk to your client, I would suggest that you explain to them who you are and what you do.
So if I'm the kids, how do you explain that to me?
How do
I have my iPhone, and so I take pictures. I've taken pictures of the outside of the juvenile court building, and we in DeKalb also have by a local author a little book that it has drawings of the courtroom, the judge, deputy who's the bailiff in the courtroom. And you spend time building rapport with your client just like you would with an adult client. And part of building rapport is introducing in basic concepts of what a lawyer is. And you really do have to reduce to its most basic sense what a judge is. A judge is someone who makes decisions for families when they're having some trouble or they need help with things, that sort of idea. But like I said, I take a picture of the courtroom. I ask them to talk about where they may have seen judges, and it's always like, the same television programs that they've seen. And then try to tease out the concept, or judges are people who send you to jail, which is often what children know of courts and judges and the system. So that way.
So since I'm attending physician for child, so how can you tell me apart from the lawyer if like given a kid and you say this is doctor and this is lawyer, so what would the basic definitions for you to give the good example to the kids and say this is a lawyer, it's not your doctor anymore?
I don't focus on the word as much as I focus on this is what I've come to help you with. This is what I've come to talk to you about. And at the beginning of every conversation with a child, I will say, I give out my business card to kids. Put it in your pocket. Can you put this in your drawer? Can you, whatever they have, can you put this in your book bag? Can you hold on to this? So I give them my card, and I will remind them my title, and I will rehearse judge, courtroom, all of that. But really, the substance is, let's talk about what's going on. Here's what so-and-so said, but I want to know what you think about it, what you feel about it. Well, here's just some things we can do about that, about this, and the counseling role begins. So.
And to explain.
Sorry to interrupt, but since I'm just a physician, I have no idea about law.
Just a physician.
So, yeah. So I have a question. Since you said that you gave them your business card, so do you worry about that, whether their parents would take that away confiscate from them?
Well, the children that I work with are either in foster care and placed with foster parents, or they're with their parents under a protective order. So in either circumstance, everybody's going to know that I'm involved. Parents are going to know, if their kids are in foster care, they know that there's a child advocate, that there's a case manager, that there's a this person, that person, whoever, visiting with their child. And it is funny. I do think a lot about, though, where the information goes when I give it to my client. And I do art a lot when I meet with my clients. We draw a lot, and we write sentences sometimes about how we feel. And then I often have you have to remember, let me take this and keep this, where they've just written a story about how they feel about their brother. Or so you do have to be mindful about making sure that you're in that rapport building session, that your kids kind of have an idea of who to share this with. Not that you're telling them not to share it with someone, but this is probably private, and
So after the last one, I'm going to go back to the first slide for 3 questions. Is that okay?
I'm sorry?
Can I go back to the first slide for 3 questions?
You know what might be helpful, and I don't mean to interrupt, but it may be that when we take a break, maybe you can have some close conversation with the panelists.
Which I was
That way
supposed
we
to
keep
say.
moving, and you'll
We're
be
gonna
able
have a
to
break.
answer that. Will that work? Yeah, of course.
Be happy to talk to you about it. I'm sorry. And I was supposed to say that. So we're going to take a break, and we're happy to talk through the break and answer questions, and I'm going to power through as I'm going way past my time. So those are the pros. The cons involved with best interests have to do that your client's wishes may not be conveyed. Oftentimes, and I've seen it before, where you're the best interest attorney and you know, that's really nice. And you go to court and you tell the court whatever you think, assuming you've actually talked or met your client, and you tell the court what you think should happen based on whatever you happen to base it on, and it has nothing to do with what your client's wishes are. No matter what, I want to underscore to anyone, no matter what your role or responsibility is, you are the advocate for that child. That child has a part in their life, that child's life, more than anyone else is affected by this outcome. You have a responsibility to ensure that the court considers what that child wants. I really would convey that no matter what role you serve in. And that their valuable opinion is often not considered. Kids know more than anybody what's going on with their family. They know that. They know they have an opinion about the outcome. They have opinions about ways it could happen and about challenges, things that you would not know. If you happen to listen and give them the credit for their knowledge and the unfortunate experiences that they've had to endure, then they will help you reach a great outcome and build your strategy to advocate on their behalf. And it also, the concept, it allows you this real broad way of kind of assessing and figuring out what you think is best. And nobody rarely have I ever heard an attorney even, or a guardian, or in whatever role, asked, so how'd you come to that out? Where'd you get that from? How'd you come to that position and outcome? And I think that we have a responsibility to be very intentional when we consider how we come to our positions on behalf of our clients. So I'm going to turn it over to Willie to talk to you about
the model that we use in Fulton County is called client-directed representation. The easiest way to describe that is the child is our client, and we go to court and represent the child as if they are literally an adult client directing their representation. There are pros to that, and some of the pros, obviously, the child feels that their wishes are being presented in court. We take off the kind of best interest hat. So there are times when we advocate positions at court where everybody is looking at our lawyers with the big question mark over their head. But because we are client-directed, we and the judge understands that, and even the client through counseling understands that, yes, this is your position, but it's not very likely to be the winning position in this hearing. Our clients understand that before they go in, but they accept that, and there is a level of empowerment with knowing that your lawyer is doing what you want them to do. Even if we don't win, your lawyer is doing what we want you to do. Another element of being client-directed is you never have the issue that sometimes comes up in a purely best interest model of your child client's desires and wishes not reaching it to the judge. You know, there's never that issue that the judge didn't hear what I wanted. When you're purely client-directed, the judge will hear what your client wants, regardless of whether it's in their best interest or not. The judge will hear that. And there is a comfort as an attorney knowing that you presented your client's wishes to the court, regardless of the outcome. So, you know, the other plus with client-directed, you know, like all the rules that govern us as attorneys, the ethical rules, they're met when you do that model. You're not dealing with, did I violate Rule 1.2 or 1.14. All those rules are met. Now there are cons, and one of the things that we want you to understand is that going forward, there are going to be pros and cons to every model of representation when you're dealing with children as clients. There are going to be pros and cons. Oftentimes, the decision on moving forward depends on whether, as in our distinct offices, you have a model of representation that you're following. In some areas, it's going to be an issue of what does your judge desire you to do in terms of your model of representation. And in some areas, it may be an issue as to which lawyer is representing the child. So we recognize that as a state going forward, that there is not going to be a right or wrong model of representation, but what the message that we're trying to get out is that there are models of representation, and what we want to move away from is kind of like going in and winging it based on your child client and based on what's most convenient with the judge. When we're doing client directed, we get pushback from the judge often. And that's just the way it is. There are going to be some judges who are absolutely resistant to the idea that a child can direct a lawyer as to what they want to do. But once you accept that model of representation, you have to stick to it and be true to it, regardless of the kind of pushback you want. You know, like our Fulton County is, I think, unique in the nation in that over the course of the years of its existence of representing children, Fulton County has been best interests, it has been dual representation, and it has been client directed. This is unique in that, and this isn't the real presentation for that, but when Fulton County entered the Kenny A litigation, it was best interests. The best interest model was used to represent children. When Fulton County entered its first consent decree, it, like DeKalb County, did dual representation. And halfway through our progression through the consent decree, we left the dual representation and went to client directed. So Fulton is an interesting study on doing all three kind of models of representation. Now there are cons with client directed, and the biggest con is that when you're dealing with infants and you're dealing with young children, how can they direct litigation? And there are models to deal with that. In Fulton County, we use the ABA standards, the NACC revised version, which talks about substituted judgment. And to kind of explain what substituted judgment is, oftentimes it ends up looking in court like best interests. However, it's a little more complicated than best interests, because what substituted judgment, that particular model, requires you to go in and investigate the case much like you would do in a client-directed situation. So in Fulton County, to help enable us to do substituted judgment, we have what they call like an integrated staff. We have investigators. We have a licensed clinical social worker to go out and look at circumstances kind of from a different lens and a different perspective than a lawyer would look at it. We also have a PhD educational advocate for those clients with diminished capacity who can't direct the litigation, but they're of school age, to give us even a further perspective on what, if we were substituting our opinion for that client might want to be the client-directed attorney to present to the judge. So substituted judgment takes practice. It's not easy, it's very complicated, and many people will say, well, that's just best interest, but it's a little deeper than that. And that's kind of how we approach our representation of children with diminished capacity, children who are newborns, children who can't direct their litigation. So at this point, I will give it back to Trenny, who will discuss the pros and cons of dual representation.
So I've talked about, I think I've talked about dual representation kind of throughout, and I won't belabor it. I think what I'll say more than anything is when I started doing this work, I worked in Fulton County years and years ago. And actually, when I started doing this work, I worked in another county, it's in Muskogee County, and I was a best interest attorney, and came to Fulton and was best interest. And we now serve in this dual role. And when you really drill down and look at the complexities of the work that we do, I don't know that I would honestly say that I would say that to truly practice in a dual role, it's really more akin to a model that's almost like a sliding scale. So when you start off with your clients that are incapacitated or nonverbal, you are evaluating best interest and substituted judgment together. And as they get older and get have more of a capacity to engage in the process, to talk about their wishes, to understand what's going on, and that's very early. I want to say that's very early. Children as young as 4 and 5 are very aware of their circumstances. That you're in your role it's more in the middle ground, that you are taking in what information they're able to provide to you, you're explaining to them, and you're evaluating, considering their current circumstances. And quite frankly, when I talk about counseling your client, the importance of counseling your client, counseling is not the same as convincing. And I talked to an attorney recently that said, and it's not, and I want to underscore that, it is not the same as convincing, right? And so that doesn't mean that as many of us move to responsibility to whatever your county is going to require, whether you'll be purely expressed with a separate attorney as guardian or a separate person as guardian, or you'll have the responsibility to balance this dual role. Counseling your client does not mean they want to do something I know that the judge is not going to agree to or that I don't think is best for them. So because guess what? Their whole life and their whole existence in this experience is somebody telling them what to do, convincing them that they can't have what they want, telling them that they don't know what's going on with them. So it's really important that you recognize that sometimes the outcome is not going to be what their position is not going to be what you think is quote unquote best for them. But you have a responsibility to counsel as best as possible. That means explain the circumstances in a way they can understand it and ways they get to the outcome they want to. And in the end, whatever their position is, that is their position. And in that dual role, once my client reaches a position, our client reaches a position that conflicts or is not reconcilable with your role as guardian for them, in your educated opinion, you can't reconcile that this would be in their best interest. You have a responsibility to conflict out of that role and to serve as their attorney in fact, right? Their express wishes attorney. So our role, quite frankly, is much more akin to that of an express a client. I never said this in public before, so now I'm on camera. So our role is much more akin to that attorney plus that I was talking about, right? Because I think that more than anything, I learned that depending upon what court you're in and who you're before and who your related counsel is, that your client's right to have their position put forward is paramount. So just very quickly, the same things that an express wishes attorney are the pros with us. You have this ongoing conflict analysis that requires you to drill down constantly to decide, in this circumstances, am I about to come into a conflict? Is this information I got, and am I now going to have an issue? And you should be doing this all throughout your case, because your job is to anticipate. It's not to wait till that child tells you that, but if you have information 2 months earlier that he's coming around again, then you know you might have a conflict, as in the scenario I gave before. A conflict may arise, and you have an obligation to assess and make those determinations as early as possible, so that if you are conflicting out of a case and serving in dual roles, the reality is at the last hearing when the child's about to go home, you ask for a guardian to be appointed, that's pointless, and you're checking off a box again. So, and Aimee will talk to you about our ethical rules, and the rules of ethics do apply. If you don't mind, I'll just power through, and I'm happy to talk to you about questions in a bit. So the cons, that some children may not have that capacity, those same cons, to form a considered wish or to really evaluate, make a determination about what they want in light of their circumstances. And there are complexities that Willie talked to you about with both substitute judgment and best interest assessments. And that the reality is, when you serve in the dual role, you might run into a judge that says, yeah, I hear all that, and I know you want a conflict, but we have a budget issue, and we're not conflicting. Or judges that tell you, I know you can manage that conflict. You can do it. You have ethical responsibilities. You are attorney first. Once you sign on as attorney or are appointed as attorney for that child, that role does not go away. You have those same responsibilities no matter what your relationship to that client is. And that's most important to remember. So the new code will require that the child have an attorney, but that attorney may serve in the dual role until or such time as a conflict arises. We'll talk about that more in detail. And some of the other models, I'm happy to talk to you about that later. They don't apply in Georgia, but I'm happy to discuss those with you. The bright line, I wrote bright light, I think it's bright line, means that at a certain age, at bright line, at a certain age, that child goes from being represented by a best interest attorney to a client-directed attorney. That age is often 12 years old sometimes. And two distinct lawyers is just that. You have a lawyer that serves in both roles. Which model is best? I won't take time with this. I ask you to read this quote, because no matter what model it is, the bottom line is, if you are providing quality representation to your client, you are pointless and you need not be there. So I encourage us not to get bogged down with whatever the title is, and understand that you have a very serious responsibility to advocate on behalf of your client, and it is a significant responsibility it's a big job, and it has a lot of things that you need to do. In practice, those are all things that I've talked about. Your client's best interest is relevant. Their voice should be present at all times, their wishes, and that counseling is key, and that it's their position, their circumstances that should be considered in assessing best interest, substituted judgment, everything, not what you think is what your background and experience teaches you. And so I'll encourage you to look in your materials to talk about to look at what we identify as what quality representation, and I think that I could speak for those of us who do this work, that these represent very basic duties of the child's attorney. And finally, this is just taken from Barton's site about they kind of did a synopsis of what our duties as attorneys in our Kenny A settlement for the child are. So I'm happy to talk to anybody about that, but that's my time, so thank you.
So y'all, I will not be able to say dependency. I won't even make you that promise. I will say deprivation. I will write you an IOU that when the law changes on January 1st, I promise I'll refer to these matters as dependency proceedings. Until that point, you know what I mean. So you've heard about ABA constructs and a model. you've heard us talk about the building blocks behind models of representation. So what I want to do for you right now is pull us back down to the citations of authority and put you back in a mind frame of Georgia law. We'll look at the rules and the code sections for both existing law and what we have to work with up until the new code takes us back. We'll look at what the new law will be. So let's start with our existing law. The child is a party. So if we're going to talk about the child's right to counsel, what rights does the child have? What are we advocating for? What are we doing for this child? So it may not sound controversial to you, but in coming into this work about 2.5 years ago, I found out that it was controversial about whether or not the child was a party. The child, under the new code, it's express. Under the new 1511.2, subsection 52, which is the definition section, party means a child. Under existing law, though, and we'll get to this in a few slides, we have to kind of cobble together the argument that the child is a party. But just grant me that the child's a party, though. And under that status, then they have full rights as any other party in the litigation. And it's kind of interesting in juvenile court how that works, where you don't have a plaintiff and just a plaintiff and a defendant, where you have this multi-party litigation. But nonetheless, child is you as counsel for the child. If you are a counsel for the child, you are doing what you would do for any other client, balancing in the other factors about your other roles. But you are, as counsel for the child, whether you are client-directed only or in the dual role, you are locked in then to Georgia's professional rules of conduct. And you've heard a little bit about what I'm about to talk about in a different slide. Like if you look at slide number 5, it's the same concepts, but again, to bring it back to Georgia, there are a few of them that I want to pull out. So first of all, I want to highlight 1.14. So that is representing a client with diminished capacity. So even our professional rules take into the account the fact that a child is not without the ability to meaningfully participate in the litigation, but I mean particularly in talking with you. So a lot of people, like when discussions come up about these issues, a lot of the examples go to a child's stated interest being, I want to go home. Well, for all of us who work in this, we know that a child's interest in this type of litigation is so much greater than, do I want to get back with my parents or do I not want to be back with my parents? You know that in deprivation cases, it's what services am I going to receive? What am I going to stay at my school? What foster parent am I with? Is somebody looking into me staying with my aunt? I don't like counseling that I'm going to. I'd really prefer that it would be a male counselor, not a female counselor. And so remember that this rule is reminding you that children have incredible input on all of those areas, and to what degree you can, you should take that into account. And then again, when you are representing a child, 1.2 is in effect, and that is you are driven by the express interest of your client. Now, of course, you've heard Trenny talk about what do you do to balance in the dual role, but do remember that you can't abandon that responsibility as attorney and just kind of incorporate as one idea what your child's stated interest is. You are driven to the degree that you can be controlled by that. You are driven by that. So on slide number 5 again, there was mention of, so if you are in a dual role, if there is a conflict between the two roles, what do you do? Well, here is Georgia's authority on what you do. So this is Formal Advisory Opinion 10.2. A question was presented to the State Bar Committee, who answered, and then it was reviewed by the Supreme Court. The Supreme Court adopted the decision of the State Bar Committee and walked through in the scenario of a termination proceeding. If you are in a dual role and you're representing the child as a child's attorney and you are the guardian ad litem, and can you advocate for termination when the child opposes termination? That was the original question that was presented. But the outcome is, but it sort of touches on, is there an inherent conflict between those roles? No, and there's also case law that holds that there's no inherent conflict. But gets to the ultimate idea that when a conflict arises, when you have an actual conflict, this is the procedure. So you have to notify the court that there's a conflict. If you're going to stay on in a role, you stay on in the attorney role. You cannot stay on as guardian ad litem, to stay on as the attorney, and then you must ask that another guardian ad litem be appointed to represent the best interest of the child. And we'll talk about some issues that come up around that in a few more slides. Sure.
This is my question to Stovall. Do you ever, I've done the dual role for TIP in Fulton, and I'm grateful that there was never any conflict, and I got my kid even though I was supposed to try to get him services. Do you ever, as the attorney in a dual role, let your child client know, as part of explaining your role as attorney, that I also have this role, and if you tell me something and a conflict arises, then I'm only going to be this or nothing, and you'll have someone new? I mean, do you feel that's part of your ethical?
Absolutely. Absolutely. Full disclosure at the very beginning. I think that that's critical. Yeah, and it should be repeated too, like at each point of contact with a child. That's mandatory for us as an office, but it's a best practice, absolutely. Yes.
And they know what to keep quiet about, in a way.
Well, I mean, in theory, you would hope that the message about I'm your attorney, there are certain things that I have to disclose if you're going to hurt yourself, if you're going to hurt somebody else. However, everything else you tell me, ... You would hope that that message is heard. But, I mean, the reality is that sometimes children are guarded in speaking with you because they're in foster care, because they're used to dealing with authorities, because they have to deal with a case manager, and things that they've told other people, like a case manager, has had a result that they didn't like, and now they don't want to talk to anybody. Thanks very much. You know.
Do you tell them that if you tell me that mom's abusive boyfriend is moved back in, I will have to, I mean,
Well, that's not my
appropriate language, but you get to that level.
That's not really my approach. Like, I don't say I'm going to have to conflict off, but
No, I mean, you would put it in age-appropriate language, but.
If I can interject, I would think in that instance, I don't know that you go into conflict analysis at the intro conversation, but if you get to a point that you have a conflicting issue, it is your responsibility to explain to them what's going to happen, because now there's going to be another person that's going to come into your life, and that person now is going to have to go back and deal with a lot of things and assess this information, and I can't guarantee you they're not going to find it. They have to know that the confidentiality will remain with you, but they should know that now, because you have responsibility to keep them abreast of everything that's happening in their case, that they'll know, or they should know, that there's going to be maybe a new guardian. That guardian's role that I told you about that I serve in now, that's going to move over to someone else, and they're going to have a separate and distinct role and different relationship, and as they secure information, because that person now is going to start coming to talk to your client and ask them that kind of information. And just as you were express counsel and were to tell them somebody else was going to be talking to them, and know that they don't have the same relationship.
But I do think it is important for them to understand, for your client to understand as best that they can at any age, the idea behind the dual role. I'm doing two things. I'm helping you in two ways. And explain, if you have a child who can understand it, explaining that there may come a time where I might not be able to do this other part of it, and here's why. But what this still means is, though, I'm not going to then go tell somebody what you told me. Okay, you can't. Nobody can make me tell anybody what you told me. So, at least, you know, keeping that connection so that they can give me a free flow of information that I need to help them. So, the formal advisory opinion remains relevant because expressly now under the new code, a dual role is authorized in both the deprivation article and then in the TPR article. So an attorney can be, one attorney can be in both of those roles. And I thought it was interesting to note that for deprivation proceedings, a guardian must be appointed, and in TPR, it's optional. I mean, it's may. So I just thought that was interesting to note. So, what are some of the unique challenges to representing children in deprivation cases? So the judge wants to interview your client in chambers, and you can stay here. We'll go talk. The judge excluding your client from the courtroom, which under the new code is expressly allowed if it is in the best interest of the child for the child not to be in the courtroom. Right now, and I hope I'm not saying this wrong, but I don't think there's an express provision that limits the child's presence from the courtroom. They still have general right to presence under other cases like the Kesterson case that you have on one of the earlier slides that I just gave you. But under the new code, if the judge makes a best interest finding that the child should not be in the courtroom, your client can be excluded. You may not be excluded as counsel from the child. That's also express language. So if you do have a conflict, of course, under the formal advisory opinion, you are to notify the court, and you are not to disclose the nature of the conflict. So what do you do when the judge won't let you withdraw unless you disclose the nature of the conflict? And then other conflict issues that you may have come up that are maybe a little unique to juvenile practice is conflict between parties or between people having different interests. So you have a teen mother who's in foster care who has a child who's in foster care, but the judge insists on appointing you to be both the attorney for the mother and for the child. So we have an attorney general opinion from 1976 that says there is an inherent conflict of interest between a parent and a child in a deprivation case. So you should not be representing a parent and a child. You wouldn't be representing the parents and the child if it's an adult parent, so you wouldn't want to do it any other way. Or if it's no longer a minor child who is your client, who is the parent of this baby who's now in foster care, but it's a former client. Now the person is 19 years old, you used to represent them, and now this person is back before the court, and you've been appointed to represent the baby who's in foster care. Still not permissible. And finally, think about this too, when you have sibling groups, especially when you got different ages, you've got a 4-year-old where the best interest idea may be one thing, the child's stated interest, may be one thing, but then you have a 16-year-old brother who finds himself in a whole different set of circumstances, wants something different, his best interest is different, so you find that you can't accomplish getting the 4-year-old to stay in care, but get the 16-year-old home. So you may have that conflict come up as well. This way. Will it advance? There we go. Okay. So pretty soon we'll have a break. I want to set up before I pass the baton over to Willie, I want to talk about Georgia law on the child as a party, just really as it relates to the child's right to counsel, because under current law, it's not as clear as what we have under the new law. So, and it's been very relevant and very important in the two cases that Willie will talk about. We had to fight in those cases to even establish that the child was a party. And so I've given you the authority that you need for the next 8 months. In case that comes up for you, if you have issues around trying to exclude your client from the courtroom or being denied the right to participate in some way because you do have a judge who says you're not even a party to the litigation. Here's where you go. So you have general law that defines who is a party to litigation. So you look at the substantive law of the litigation to determine if that person's rights are affected. And I gave you the cites that some cases I think are great that delineate what are children's rights in deprivation case. And for the liberty interest, there's a fantastic article that I didn't cite that if you'll see me, if you're interested in this, I can get it for you, that also challenges you to go beyond what's listed right there and think widely about what children's liberty interests are in litigation. So just want to note that in case you're interested in that. But then go into juvenile law, and you have basically there are two things that we use. We use the McBurrow case, and we use 1511-6. And so our juvenile code for McBurrow, our juvenile code, are all parties, including the child. And then we use 1511-6, the part at the bottom that's highlighted being the most relevant. Counsel should be provided for a child whose interest is not represented by a parent, guardian, da-da-da-da-da. And then we also use the attorney general opinion that says there's always a conflict of interest to trigger that. So that gets us to the child being a party. And then that gets us to having a right to counsel, or vice versa, actually. So in TPR, it's a little bit easier. There's a statutory right to counsel. There's the site for that, 1511-98A. In deprivation cases, once again, we use McBurrow and 1511-6. Did I get that right? And then finally, especially really important to us, though, is Kenny A. And it holds that, this opinion holds that there is a constitutional right to counsel, which we've all believe very strongly about, but don't have binding authority in Georgia. We also don't have a U.S. Supreme Court case that holds that the child has a due process or constitutional right to counsel on the federal constitution, but persuasive authority. And then I probably should have put in parentheses by CAPTA that this is guardian ad litem language, really, more than right to client-directed counsel authority. In a judicial proceeding, a guardian ad litem should be appointed. But I did want you to know about the federal site to CAPTA. So this is what we were working with. We have some pretty good authority the child is a party. We have some pretty good authority that the child has a right to counsel, and we're advocating for our children, and we are active, and we are killing ourselves in juvenile court, and we're doing everything we can to get justice for our kids and have their needs met. And then that, of course, doesn't just stop at disposition. It means filing appeals. And so we're filing appeals. And then we hit a bit of a barrier. And so we had two major cases come up that Willie's going to talk about, and I'll just set up a little bit of the law that was in place that led to those cases. And it basically came down to the court saying, well, look, children lack capacity. They can't be directing litigation as minors. They can't come to our courts and have their appeals heard without someone, SWE, generis to, a next friend to drive this litigation for them. So who will that be? And there became a battle over, well, in our existing juvenile court system, who would that be? And in juvenile code, we have a guardian ad litem section, but in every other part of civil litigation, they've got the CPA and all the cases that are born around it, and they don't match up. A guardian ad litem in juvenile court is not a guardian ad litem in other areas of law. So in other areas of law, you consult with, mom comes in and her child went to the doctor, the child was injured by the doctor, mom wants to file a medical malpractice suit, and yes, your client is, or the victim was the child, but really you're doing so much of your work with a parent. And the parent is making all the decisions. Well, we don't have enough money to go through the next 4 years of this case, so why don't we, we'll consent to settlement. Not the case in juvenile court, because again, there's an inherent conflict between the parent and the children. Or in this case, the role of a guardian ad litem is to present facts to the court about what the best interest of the child is. It's not someone who steps in and makes decisions for the child. So, or that's how we see it. That's how I see it. But we do have a crossover from this other guardian ad litem concept over to juvenile court, and we get these cases where the child is made a party to the litigation through the guardian ad litem. And from that, we find ourselves at WLH and JCW. But just one quick thing, the reason I have these here for you is that there was a time where it wasn't, I started to phrase this as if it wasn't on the court's radar. I don't know, it's maybe not, I don't know if that's totally accurate, but you do see, I just kind of like did a little cut and paste of some cases out of different counties where children were reaching the appellate courts through, conceivably through an adult representative, but let me see, I'll tell you, I know it's a little bit hard to see, so.
Is that what you're looking for?
Yeah, I need my slide there. Okay. The point of this being only, though, that you have 4 cases there, and one of them is a DeKalb County case, 2003, Court of Appeals. It says, through the guardian ad litem. Fulton, 2008, through their guardian ad litem. Wait, that can't be right. That's Fulton County. Cobb County, 1997, guardian ad litem. Walton County, 1999, guardian ad litem. Next one. You've got a 2011 Fulton County case, just the minor children appeal. No guardian ad litem in this one is mentioned. And then you got Fulton 2009, it's the child advocate attorney who's bringing the appeal. So the court wasn't really policing who was exercising the appeal right for the child.
Yeah, and if you really, really get into it, I don't know that the Court of Appeals was even concerned about the role. Because we have, in Fulton, we have the same attorney appealing and being called guardian ad litem, child advocate attorney, in the same litigation but on different appeals. So I don't think the court, until we reached this point of WLH, was even aware of what the person was who was filing the appeal. Depending on the panel, it was either the guardian, it was the child advocate attorney, or it was a combination. And they weren't really focused on it and what it meant up to that point. So this is where we'll take our break, and we'll pick up after this and talk about this whole concept, not really of right to counsel, but of standing to appeal, regardless of right to counsel. So this is where we'll break.
Before Willie gets started, I was reminded that I did not express that the first model we talked about, attorneys representing the best interests of the client, no longer exists under the new code. I'm sorry. Thank you so much, Judge Hill, because you have to represent the child's expressed wishes. So I want to make sure that I underscore that.
As the attorney.
As attorney.
Right. There also under the new code, and we'll talk about this, there is a guardian ad litem for every child in what will be called dependency cases. And the duty of that guardian ad litem will be to communicate to the court what that guardian ad litem believes and is trained to articulate is the best interests of the child. And you know, guardian ad litems in Georgia can be attorneys, they can be lay people, and they can be CASAs. There are different guardian ad litems, and those will be really, really active and in every dependency case in the new code. So that's kind of important. Now, this is kind of the whole idea of standing. It's not the same as a right to an attorney. Standing is the ability to present a case in court. Now, and you know, we have this discussion all the time. I think everyone involved in the legal system in Georgia is comfortable that a child has standing in the dependency cases that go on in juvenile court. I call it a tripartite or three-party system of representation where you have the child as a party, you have a parent as a party, and you have the state who is presenting the case as a party in juvenile court in deprivation and dependency proceedings. Everybody's comfortable that the concept of party, well, not everybody, but most people are comfortable that the concept of party exists in dependency cases, and once the new code comes out, by law, those three parties will exist and have standing to proceed in the juvenile code cases. However, but what does that mean for appeals? Lawyers know that part of being a lawyer is the ability to file an appeal when your client does not agree with the result of the trial court. Everyone knows that. But how does a child decide to tell a lawyer, I want to appeal? How does the child do that? And even more interesting is when you have a child who is not capable of expressing the question, I want to appeal, how does that get up as a lawyer in front of judges at the appellate level? And recently we've had a few cases that are beginning to look at this issue. The biggest case, and the case that has been decided by the Supreme Court of Georgia, is called WLH. It was entered on March 4th, 2013. And in that case, the raw holding is that the child does not have standing to appeal. Now, there's some additional discussion that we'll have beyond that, but the raw holding, and lawyers need to know, because lawyers representing children who decide to appeal, you know, like I've had a judge approach me and say, So I guess your attorneys will not be appealing anymore after WLH. I've had a judge literally tell me that. And of course, I gave him my elevator presentation that I'm about to give you because I don't believe that that's the case after WLH, but that is something that attorneys representing children are going to have to face. In our office, we have litigated this issue. Aimee gave you several cases from Fulton where we have been allowed to appeal. And the biggest case where, because of the way that appeals work, the Supreme Court decision had not come out yet. However, the Court of Appeals had said, sua sponte, that children don't have standing to appeal. And we had filed an appeal that had been up in the Court of Appeals, and they asked us the question whether your child clients have standing to appeal. And we were fortunate to get an opinion in late November of 2012 that said, yes, these children do have standing to appeal. Now, of course, in March 2013, the Supreme Court said children don't. So where are we in terms of children having standing to appeal? Now, you know, the concept of standing, again, is the ability to bring the case. It's not the ability of having a lawyer. It's not a right to counsel. It's the ability to bring a case. So this is what the Supreme Court said in WLH. In this case, we granted an application for certiorari from the Court of Appeals decision in Ray WLH to determine whether a child in a deprivation action has standing to appeal when the child is represented by counsel, it's not an argument there, and the guardian ad litem. In this particular case, the child had both an attorney and a guardian ad litem. That will be the case under the new code. Every case going forward, the child will have an attorney and a guardian ad litem, sometimes the same person, sometimes not. But the guardian ad litem chooses not to appeal. And this is the reasoning and the holding of the Supreme Court in March. Because the guardian ad litem is the legal protector of a child's best interest in deprivation proceedings, we find that a child lacks standing to appeal a deprivation ruling except through a guardian ad litem. So, you know, nationally, the child welfare community is disappointed with this opinion. In our office, it presents a challenge. In offices like DeKalb County, where the child attorney is also the guardian ad litem under the dual model of representation, it may present less of a problem, but we don't know whether it will yet. So we don't know because after this holding has come down, attorneys representing the parents in all of our cases say, when we appeal, they say that we don't have standing to appeal. That's their argument in their response brief. We do not have standing to appeal. So for those of you not familiar with WLH, and one of the attorneys from Walton County is here, if you have some questions about the facts of the case, these are the basic facts. They're in the slide. I'm not going to go over these in details, but these are directly from the opinion. But the bottom line is you had an attorney representing the child in juvenile court who decided to appeal, and you had a guardian who opposed the appeal. And those are some of the unique circumstances of WLH. That it does not happen often that you, one, have a guardian opposing a child attorney's appeal. That does not happen often. So in my mind, that is a unique circumstance of WLH that rarely exists in other cases. This was a deprivation action also. So in many deprivation actions, especially in Fulton County, there's not even a guardian ad litem in the appeal. So you have to look, you know, the devil is in the details, as we lawyers know. So you look at the details and you look at these unique circumstances. You know, the critical, in my opinion, distinction in WLH is that the guardian ad litem was appointed an attorney to represent them on the appeal, and that attorney filed a brief opposing the appeal. Now, as far as I know, that is unique in deprivation and will probably be unique in dependency actions, but again, we don't know. But these are unique circumstances that you have to be aware of when you look at the holding in WLH. And as attorneys representing children, these are facts that you have to point out. Now, there was a vigorous, studious, well thought out dissent filed in the WLH case. And I would encourage people who are representing children to read the dissent, because for people who do this all the time, it seems to like hit on all points and to be right. But it didn't get the votes to be the majority opinion. But it is good reading. You know, nonetheless. You know, so, you know, one of the things the court in the Judge Hunstein in her dissent pointed out that it disregarded the child's express wishes. The child wanted to appeal. It offered insufficient legal analysis, correct. And it failed to provide needed guidance for our juvenile courts. The majority opinion holds that a community volunteer serving as a guardian ad litem, no legal training, is the only person who can appeal on behalf of a child in a deprivation action, regardless of the child's age, the ability, you know, if this was an 18-year-old, this would apply. Regardless of the child's age, the judgment of the child's attorney, who is trained in legal proceedings, but, you know, like not, you know, the guardian, or any other circumstances. You know, the majority opinion failed to acknowledge differences that exist in child representation in the state, and holds that the role of the child's attorney in deprivation actions is subservient to a lay guardian ad litem. So for, you know, for attorneys, it's kind of hard to look at the majority opinion and feel good about your role as an attorney, setting up strategies, maybe setting up a very strategy to appeal, and then, you know, like at some point have a lay guardian ad litem appointed by a judge and paid by a judge say, I oppose it. Even though you've done all this legal work, a layman can come in, get a check and say, I oppose it, and, you know, like all your work. And really what's best for the child, as from a legal point of view, goes down the drain. So these are things to think about and to fight. when you're representing a child. So, but, again, all hope is not lost. In our case, the overview, we were representing infant twins, so they could not direct the litigation. And they had been with their foster parents since they were 6 weeks old, had formed bonds with the foster parents, yet the parent attorney wanted the children removed from the foster parents and placed with relatives after the mother agreed for non-reunification. The mother agreed. However, she wasn't happy with the placement, and there's an issue as to whether that's appropriate. Once you agree to non-reunification, do you get a voice in the placement? But these are all the kinds of issues that we were dealing with in Fulton. And as we have been filing appeals, the parent attorneys, and this is directly from the case, moved the Court of Appeals to dismiss the appeal because the twins lacked standing. And the lack of standing was based on that time the Court of Appeals opinion in WLH, not the Supreme Court opinion, but the Court of Appeals opinion. So, in looking at the issue, again, good language for child representatives when they're trying to appeal if you want standing. The court distinguished the Court of Appeals distinguished what they did in WLH from the circumstance in this case. And one of the things, if you look at the last sentence, they say in WLH, the child had both a guardian ad litem and an attorney, and the guardian ad litem filed a brief opposing the child's appeal brought by his attorney. Honestly, and I've talked to practitioners around the state, that just doesn't happen often. This may be, I can't say ever, but this is the only case in recent memory. And, I've been practicing. I'm going to my 25th reunion later this week. I've been practicing 25 years, and I've talked to practitioners in this area, judges in this area, and nobody can recall another case where this has happened. So it is unique. But, the cool thing that the Court of Appeals noted in our case is that, the children did not have a court-appointed guardian ad litem in our case. And so the child attorney who had been representing them from 6 weeks until the current, when the appeal was filed in this case, was the only adult representative who understood and knew what was going on with these children. And, the court went on to hold, now that the issue is squarely before us, we are reluctant to conclude that the children in this case lack standing to appeal through their attorney. It cannot be questioned that the children are the real parties in interest whose lives will be directly affected by the juvenile court's decision regarding custody until their 18th birthday. And while the children do not have a guardian available to contest the juvenile court's ruling on their behalf, they do have an attorney who has advocated on their behalf in juvenile court and now seeks to do the same on appeal. So, you have to look at the facts of your case, the circumstances of your case. In the current setting, and this is based on conversations with judges from different circuits, it's going to be rare that you have a paid attorney and a paid guardian ad litem in the same case. It's going to be very rare. And one of the reasons that in the new code in Section 104, because this was a compromise. You know, I was always there fighting. We need both a guardian and we need an attorney. I was the guy testifying. We need them both. And, you know, I got shut down by the Judicial Council, and it was like, no, we can't pay for both in smaller counties, and that's just a reality. So, you know, at that point, although it's on the record, my mouth was zipped because it was better for the code to pass than, you know, this long. I would have lost anyway, but, you know, the point is, you know, like that argument for opposition, you know, for the greater good, you know, I agree that, you know, it's best in circumstances, and it works in DeKalb County. So it's not like it's in my mind, it's cleaner to have a guardian and an attorney, but for it to be both, it's not an unworkable solution, you know. So, you know, what the Court of Appeals did in our JCW case, they determined that dismissing it on appeal under those facts and circumstances would be a miscarriage of justice. I like that. You know, this is unrelated, but a long time ago when I was in Georgia's Governor's Honors, in a social studies session, we were doing a debate and over abortion and whether, I think, you know, it was based on Roe v. Wade. And I remember this guy from Lovett, who was a great debater, he was like, if we go with this position, it will be a miscarriage of justice, and I mean that, you know. And it was really funny to see that little argument come up, that little phrase. It just brought back memories, and that's just an aside, and it's not relevant to this discussion, but it just brings it up. So, you know, we were able to get standing to appeal, and we actually got the juvenile court's decision reversed. And, you know, if anybody wants to know the subsequent history, we, using, you know, legal arguments and filing motions, we recently had a rehearing in the case, and the juvenile judge decided that the children should stay with the foster parents. So when people say children need lawyers to do what's best for lawyers, that's a good example where, you know, a lawyer made a difference. You know, science shows that when you separate children, regardless of the circumstances, when you separate children from their parents, they experience trauma. Science also shows when children attach to a new caretaker and there's bonding and you separate them, they experience trauma. So the lawyer in this position was arguing science. There was a bonding expert that we put up at the hearing that argued that a further separation would create trauma, and the court reversed its prior decisions and kept the children with the foster parents to avoid additional trauma. Now, in all likelihood, I'm certain that the parent attorneys might appeal, but you know, they're you know, like hallway conversations where you try to persuade people that, you know, what's happened might be best. So we'll see what happens there.
Just real quickly, if I can, Willie, I just want to underscore what a victory it was to get the ruling that said black and white. It cannot be questioned that children are real parties in interest. So everything that I gave you before about, well, we used McBurrow and we used this and we cobbled it together before JCW, now we actually have authority to say strongly children are parties. So
use it. When you're representing children, use it. And that case was not, there was no cert petition filed. So that is the law. That is the law now in Georgia. So where are we now? As I tell you, we're still gonna appeal. Our office will still appeal. We're client directed, so we're not guardians and we still appeal. And so most recently, we filed an appeal on behalf of two siblings in a termination of parental rights case, and the Court of Appeals looked at it, and they said, sent us a question back where we had to file supplemental briefs on standing. So you may get, questions about whether your child clients have standing to appeal. We have filed our supplemental briefs, and there has not been a ruling yet, but once there is a ruling, we'll know kind of how the law is developing and what kind of future fights may be ahead for us. Because I promise you, if we lose, we will file a cert petition to the Supreme Court and ask them to review their holding in WLH. WLH is what it is. So, one of the things that I have been discussing with the management in my office is like, do we accept it or do we, continue going, or in the meantime, what do we do? We're looking at possibly filing motions in all our existing cases for our attorneys to be appointed as guardian ad litems for the limited purposes of appeals, not for the, trial court proceedings, but for the limited purposes of appeals, and we're looking at filing it in all our cases so that there's no question if we decide to file an appeal. And, one of the things, there's this idea that, like if attorneys can appeal for children, there's going to be a flood of appeals and many of them are going to be meritless. That really doesn't happen. That has not been our case. We handle like over 1,000 cases per year, 1,000 different child clients per year. And there's not a flood of appeals that we file. So that there are a lot of what I call boogeyman arguments about what's going to happen if, children can appeal, but it's just the facts are not there. So now Aimee and I will talk to you about, like some of the things coming up in the new code, so. Oh, okay. Yeah, so yeah, we're gonna let you review the new code. We have it in our presentation, but we know that there are probably questions, and I've engaged in some vigorous debate during the break. So we're gonna open this up for questions. But yeah, basically the new code, in a nutshell, the child is a party. The child shall have an attorney. The child shall have a guardian ad litem who may be the same person as the attorney. So that, in a nutshell, was some of the new code section things that we were going to discuss. But, in respect to your time, are there any questions from the audience that you'd like to present? Yes.
Foster parents during your case?
As it turned out, the twins were briefly removed but returned to the foster parents because, of course, there were issues when they were removed. So they did stay with the foster parents for all but 9 days while the appeals were going on. Yeah, I should repeat the question. The question was, did the twins get to stay with the foster parents during the appeal of the case? So, yes.
In your twin case, where were the aunt and uncle when the diligence started to made at the beginning of the case?
They were not revealed. The mother did not reveal them until very, very late in the case.
So, and let me say, so underscore that here, this is an example of when you talk to your client. Because diligent search, if you've ever been in juvenile court, one day, a diligent search, have you conducted a diligent search? Yes, Your Honor, I have. And you're on to the next. There's very rarely, if ever, any kind of voir dire, no questions about what that means, how it looks. Children are very aware of their circumstances, and they can provide a lot of insight into that kind of information about connections, family connections and opportunities. And that you as the attorney also have the opportunity as attorney for the child to examine the department about how or what they did to conduct a diligent search and to make recommendations about, you know, modern things they might try, like the internet. I'm just saying.
There's a question over
Yeah,
here.
there was a question.
Regarding a child's standing to appeal, where do other states stand on that position?
Most states, you know, and we did research this, most states, Georgia's holding is in the majority.
It is.
It is. It is. It's not, and just so you know, if you start representing children, you know, like the ABA has in their litigation section a right to counsel strategy group. And we have monthly conference calls, and we keep each other updated about what's going on around the nation. And to be honest, paternalism rules. You know, the idea that a lawyer and a child can do things in court is not the majority opinion around the country.
But the fight is on.
But the fight continues, and we need people to fight. Yes,
I'm
sure.
just curious about the assertion that it will be a problem for the dual role attorney going forward under this current ruling with WLH. And I was just curious why.
Why do I feel like it may be a problem? Well, I don't want to speak specifically about my county. Let's just talk generally. So maybe it seems like it's favorable for us because we serve as guardian, but let's just assume that where a court might normally appoint a guardian for a very specific, for the traditional role of a guardian, there are certain instances, and you guys, and this concerns me, in counties where attorneys aren't always appointed, and now there will be this requirement. There are circumstances where judges don't necessarily appreciate yet one additional attorney making things more difficult. And I'm concerned about the idea that putting it in someone's head that, oh, there's a chance to appoint an attorney who may be seen as directing litigation at any stage. So if this attorney is appointed to direct litigation on appeal, and you have judges who aren't comfortable with the idea of a child having a client-directed attorney or an attorney who's making the situation more difficult, the court may decide that, you know, I think I'm going to have that same, give a broader or more defined appointment of a guardian. And that's where my concern lies. And so even though we serve in a dual role, our responsibility, as I stated, we really do respect our clients' expressed wishes. And so we're much more akin to, much more aligned with express representation than the kind of the guardian paternalistic responsibility. And I'm concerned about what happens when you put that idea out there that there are states and there are jurisdictions where the counsel represents the guardian as a matter of principle. And I just don't like the idea that that could.
Yeah. And just to follow up on that, and I will recognize the next question, but to follow up on that, in our ADP case that they just asked a question in, it was a termination of parental rights where we were the petitioner. Our office petitioned for termination of parental rights after we had gone through the deprivation proceeding. So a guardian was appointed in November. We had the TPR hearing in March, and the guardian felt that the children should be returned to the parents. So you have a guardian. Now, this guardian did not oppose the appeal, but the position that the guardian took with only 3 months into a case where one child had been in the care for over 2 years and the other one for close to 1.5 years, the position that the guardian took was to side with the parents. So, you know, the argument was made in dismissing the appeal that the guardian although he didn't officially oppose the appeal, he sided with the parents below. So, I mean, those are the kinds of issues where, you know, I think that the appointment of the guardian, when you see it practically occurring like, you know, like right at the TPR, may not necessarily bode well.
Yeah, it was really
Like if
concerning.
they petitioned, you may get another guardian appointed. If you petition, yeah.
Yeah, right, very positive. I'm just really concerned in any way about anything that diminishes the role of the attorney. I really am.
Okay, there was one last question.
One more time.
Yeah, I thought I saw a question over here.
The doctor?
Oh, yeah. Thanks so much for taking my question.
Yes.
So, as my take-home message from this workshop was to try our best to represent the best interests of our clients, right? So, my question as a physician is like, what is the fundamental qualification for a trial attorney to represent the best interests of your client?
What is the
What's the
fundamental
fundamental what? I couldn't-
Qualification.
qualification? To represent the best interest or that client's position? So
Yeah.
that client's position. So we're really trying to espouse that the client's position, which might be distinct from best interest, is paramount. My client I may not think that's best for them, but what is our qualification for representing our client? Is that your question?
Well, it's like not just going through the bar and you can get your.
So Georgia has certain standards with regard to training. So our bar offers guardian ad litem, certain child attorney trainings that are necessary. In our department, in our office, we both have very structured offices. We're about to have a state where everybody's required to be an attorney that may not have those. For us, our attorneys receive a minimum of 6 months mentorship before they're in the courtroom along with clients. They train with our investigative staff. They train with. They're required to take quite a bit of trial practice trainings, as well as quite a bit of other. I would have to talk to you offline about the detail of the training that they're required to have.
Yeah, and in Fulton, we have a, I guess, protocol for appointment of attorneys to represent children who are not from our office, because there are conflict cases where if, for instance, we represented the parent when he or she were a child and now their child is in care, we have to conflict off because we have a relationship prior to. So the new attorney coming in, there are standards of training that attorney must go through before they're appointed.
Yeah, just a few seconds. So because I'm a member of American Academy of Child and Adolescent Psychiatrist, and to me, based on my experience, the hardest part to be a child attorney or maybe the same as a child psychiatrist is to gain the trust. Mm-hmm. So my question is, how can you gain your trust? It's the fundamental qualification to be a child attorney.
Continuity in your relationship with your client. You talk to them, you spend time with them.
Just like, for example, I'm the kid, I come to you. Not I come to you, I was signed to you by the law. So what would you tell that kid and say, we are on the same ship, don't worry, I'm on your bed. I'm not on the side of the parents or guidance. Mm-hmm.
You know, I don't think there's anything that you can tell a child. Mm-hmm. A child is gonna look at how you behave. Yes. So when you are representing the child, and in our office, when we go through, we're going to present your position to the court. We're going to do this because this is what you want. The child looks at what you do as that child's attorney, and that's how you build the trust. It's not anything that you can say. Because we can say that we're going to do something, and if we go to court and do the exact opposite, the child is never going to trust you.
Right. Yeah, this is the last point.
I'm sorry. I will hold some questions. I think the panelists will be hanging around for a few minutes afterwards, but I want to get in like our closing announcements and make sure that we excuse everyone with the right amount of time. So I'm going to ask you to hold on to that 1 second. And I just want to ask all of you to join me. As you can tell, and I think you'd agree, these issues are very much alive. There's lots more discussion that it needs to be had and will continue to be had, but we're very fortunate to have these folks and many of you all helping to clarify and challenge and lead this and inform this discussion for children in our state. So please join me in thanking one last time our speakers, our visiting scholars in practice today. And then I want to make sure you're aware, you heard lots of allusion today to the new juvenile code, and many of you are very aware of and perhaps were very involved in that effort. Through our Child Welfare Legal Academy series, we're going to start to offer a series of workshops that will look at the new code overall and then in more depth in individual sections. So our next Child Welfare Legal Academy will be Tuesday, May 14th. Change of time, it will be from 8 to 10 a.m., which is rough, I know, but for everybody. But the goal is really to hopefully get people before they enter court on one of those busy court days, as well as we're going to structure that event slightly differently. We will host a live presentation here on the campus in Toll Auditorium, which is just downstairs, and we will broadcast over the internet live to certain local jurisdictions across the state. Those sites are to be determined. I assume most of you all are local here, so you're welcome at Toll Auditorium, and I hope we can have a great live presentation and lots of discussion with good attendance here live. So that I wanted to make sure you were all aware of that. As I mentioned before, all the materials and the lecture from this today, as well as all of our other series, are posted online for your later reference and use in training, perhaps, and conversation. And then finally, as an administrative matter, please complete your evaluations. We really do review those and get lots of good ideas from you all. And you can also trade that in exchange for your parking validation at the registration table when you leave. So thank you all so much for coming, for supporting our program, and we look forward to seeing you next time.